Welcome back to the Emily Show. Today is a travel show, so if you are watching on the YouTubes, you will see that Emily is traveling. If you are listening on your favorite audio app, nothing will be different for you, I promise. Today we have quite a lot to cover. We have Tom Girardi updates, quick Kohberger updates, a quick update on Denise Richards and Aaron's divorce. We got to talk about that for a minute. And then unexpectedly, a Murdaugh update. So for those of you like, Alex Murdaugh, girl, really? Yeah. I know. I didn't expect it either. So those are the things we are going to talk about today. As always, if there is a case or cases that are your favorite and or not your favorite, on YouTube, we timestamp everything so you can jump to the topics that you want to hear about the most. I try to put the show in order in a way that makes sense in my brain, but if it doesn't make sense in your brain, feel free to, you know, as the House of Pain says, jump around, jump up, and get down. Emily, let's get into a podcast. I agree. Let's get into a podcast. There is lots to talk about today on The Emily Show. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. First, talking about Bryan Kohberger. There was a hearing for Kohberger on Thursday, July 17th. I was on an airplane. We haven't had a chance to update. It was a very quick hearing. As I said last week on stream, I anticipated that the judge would lift the non-dissemination or gag order in this case, and he did. What I was not expecting is that it was the defense that objected when those filings finally hit the public docket, not the prosecution. Does that have any practical effect? No. Will we talk about it on Tuesday on stream? Yes. The judge lifted the non-dissemination order, so you are going to see more articles, especially running up to the sentencing. Remember, the sentencing in the Kohberger case is happening on Wednesday, July 23rd. I will be covering that live, so join me on the Emily D. Baker live stream channel. If you don't have the Law Nerd app and you're not sure how you're going to get notified, the Law Nerd app at lawnerdapp.com. It's free. It uses notifications through the app to let you know when I'm streaming. So we are going to stream that. It will be a full day. It's going to be a heavy and emotional day because we are going to hear the impact statements from those that choose to make them. I do not anticipate we will hear from Bryan Kohberger or his attorney, though we may. And if you've seen the headlines about that hearing on Thursday, you might have seen that the judge made a statement about Bryan Kohberger's right to appeal. And you're going, but girl, he waived his right to appeal. Yes, he waived his right to appeal. But that does not stop him from filing an appeal. What it does is it directs the court, if an appeal is ever filed, that they go, okay, well, you waived your right to appeal, so no. And we actually saw this in the Murdaugh case more than a year ago, where he had filed an appeal and the appellate court went, you waived your right to appeal. It's here. You signed it. You understood it. We're done. So yes, he can still file if he wants to, but he doesn't have the right to a remedy on appeal. Could he try to say he had ineffective assistance of counsel? Sure. I mean, he could try it. He could try anything that he wants to. It doesn't mean it's going to work. It's not going to change his plea. There were also statements made about things happening at sentencing. I think the defense was indicating they didn't want the Kohberger case to get any more divisive or vitriolic because it seems that there have been threats leveraged towards parties on all sides of this case. The court indicated that they didn't want to be contacted in this case during the plea hearing. And I don't think that indicates in any way that he's withdrawing his plea. I think they are concerned, and I think those concerns are safety related. So I don't anticipate we're going to see anything like Bryan Kohberger trying to withdraw his plea. And the sentence in this case is predetermined. It is 4 fixed life sentences. What that means in Idaho is that it is not a indeterminate sentence, meaning it's not a range of years and then parole gets to pick. It is a fixed sentence, fixed at life. In Idaho, that is defined as for one's natural life. So if there is not a death certificate, you are still serving your sentence. That is what he is going to be sentenced to, 4 consecutive life sentences, plus 10 years for the burglary. We will see that on Wednesday together if you want to join the Law Nerds while we watch it. So those are the Kohberger updates and what I expect we will see in sentencing. I hope to see you in the chat. A huge thank you to today's sponsor, Honeylove. And yes, today's podcast is a podcast where Emily is on the road. You know what I pack every single time I travel? My Honeylove. I absolutely do. Why? Because, well, one, it is incredibly comfortable and your girl lives for comfort, but it's also easy. I don't have to make decisions. I know what I am reaching for. every single time I want to pack. And what I appreciate about Honeylove is how cool their underpinnings and sleepwear is. Do not sleep on the Honeylove sleepwear, because Honeylove is all about keeping you cool, comfortable, and supportive. And when it comes to their bras, that's where their cutting edge technology comes in. Honeylove's bras aren't bulky, and they have incredible wireless support that feels like a second skin. Lightweight, breathable, perfect for hot summer days. You have just the right amount of lift without all the uncomfortable squeeze. So you get the shape and hold you want without the bulky underwires because of their smart design. So if you are ready to treat yourself to the most comfortable and innovative bras on earth and save 20% off site-wide, go to honeylove.com/lawnerd and use our exclusive link down below to get 20% off. honeylove.com/lawnerd. And if they ask you at checkout where you heard about Honeylove, please let them know that the Emily Show sent you. So get ready to experience the new standard in bras with Honeylove. Let's get back to today's episode. Last week, I asked if y'all wanted me to go over the Denise Richards divorce a little bit more. In the meantime, Denise Richards filed and received a temporary restraining order against her estranged, because they are in the middle of a divorce, her estranged ex, Aaron Pfeffer. And in that filing, it seems that she included photos of some physical violence that she is alleging came from Aaron. I say alleging because this has gone through the TRO process, which is a very cursory process, and there is more process left to go. I am going to be covering this more, though not today, unfortunately, because the entire LA County court system is down online. And so I don't have all the documents I would want to cover this, because if we are going through the temporary restraining order, I do not want to go from reporting on it. I want to pull those court documents. And while I am on the road and the entire court system is down, I cannot. Though I am very glad today is not a day that I am trying to be in court in Los Angeles, because it seems like a nightmare for everyone involved. But I really want to bring those documents forward. A few of the questions I have seen regarding this, because Aaron is the one that filed for divorce, and per reports that had an ask of a substantial amount of spousal support, indicating that Denise Richards is the one working, that he is not working. We will talk about that more when we have all the filings to go over together. But yes, proven allegations of domestic violence can change whether or not spousal support will be granted. There is going to be a lot more to come in this divorce filing, and we will go over that. But I do want to do it from the documents, because that's how we do things. So once we have those, we will go over it. So for everyone last week who said, yes, I'm interested in hearing more about this, I hear you, we will. Apologies that it's not today. That was my anticipation. But apparently court websites are dynamic, and it doesn't truly shock me. Remember that the LA court system went down completely with the Cloudflare outage, and then they had a intrusion into their system, and so they changed over their system. So I'm interested to see if we learn any more about the court being down, or if it is just part of the system changing over. I guess we'll see. But speaking of Los Angeles, and speaking of Los Angeles lawyers in court, well, this is a lawyer that's not going to be in court anymore, because Tom Girardi's no longer a lawyer because he was disbarred. But former attorney, disbarred attorney, disgraced attorney, felon Tom Girardi did actually report to prison. I know. I didn't know if we would see it either. When this whole process started and I started covering the bankruptcy and divorce in 2020, I did not think that we would necessarily see the day that Tom Girardi went to prison. I don't think Tom Girardi thought so either, because he has tried every which way to talk his way out of this. How do we know he turned himself into prison? Yes, there have been media reports on it, but I also want to share the court document talking about this, because last week we discussed that Tom Girardi was asking for a bond pending appeal. And I indicated that sometimes the court will grant those bonds pending appeal if the appeal might actually take longer than the entirety of the sentence, or if it's going to be close, or if there are really strong issues on appeal that the court sees, they might grant that then. We are taking a look at a court document filed July 14th that indicates what is going on with this case. So this is the notice regarding the court's order of July 10th, which we covered on the last podcast. And it says, defendant Thomas Girardi, by and through his counsel, submits the following. The court's order of July 10th directed the parties to meet and confer and inform the court of a mutually agreeable date upon which defendant's motion for bond appeal may be heard, and clear that date with the courtroom deputy. And it goes on to say, as point 2, that the court asked the parties for their positions on whether Girardi's self-surrender date should remain as currently set on July 17th. So they're just reiterating what the court asked them to do. The attorneys notify the court saying the parties have met and conferred. The parties request that the court calendar a hearing on the motion on September 11th, 2025 at 1:30. The date is agreeable to the attorneys and has been cleared with the courtroom deputy. Neither party seeks to change the currently set date for Girardi's self-surrender. The parties agree that should the court order bond on appeal at a hearing conducted after Girardi's self-surrender, the court could order Girardi's release from the Bureau of Prisons custody on bond pending resolution of the appeal. So all of the attorneys agreed that Girardi can go into custody, which he did on July 17th, 2025. And then if a bond is issued on appeal, he can be released. What this indicates to me is that the defense is mindful of the fact that it is unlikely that he will get a bond pending appeal and that he will serve that time in custody while the appeal is pending. The day has come and Tom Girardi actually went to prison. And it just seems appropriate that we move from Tom Girardi to Alex Murdaugh, because attorneys stealing from their clients should not be cases that we are talking about as frequently as we are. But Alex Murdaugh's lawyer, Dick Harpootlian, keeps chatting about this case, and I was very surprised to see the headlines that Dick Harpootlian is now saying that there is evidence that was not turned over to him and the defense team during the Murdaugh trial. Remember, Alex Murdaugh was convicted of the murder of his wife and son after a jury trial. He also pled guilty to all the financial charges, both at the state level in South Carolina and at the federal level. And so he is serving time for a number of different things. Since the trial ended, the defense has been making a motion for new trial, and that motion is up on appeal. One of the bases for their motion for new trial on appeal is the argument that the clerk of court, Becky Hill, influenced the jury. The law is different in South Carolina than it is federally. So what the defense is pressing for is really for South Carolina to adopt the federal standard. Under the federal standard, which we've talked about at length in other Murdaugh coverage, but under the federal standard, the defense doesn't have to prove that the jury was influenced. They just have to prove that someone was spoken to from a court officer about the process. And now that former clerk of court, courthouse Becky, has been charged with perjury, among other things, stemming from her involvement in the Murdaugh case, it will be interesting to see how that plays out in court, because if the standard changes, it could allow a new trial for Alex Murdaugh. Under the South Carolina standard, Chief Justice Toll found that the defense had not met their burden and therefore a new trial wasn't warranted. The South Carolina Supreme Court is going to have to take this up. If there was anyone to change the law in South Carolina to fit the case law federal standard for when there is a state actor talking to a jury or potentially influencing the jury or interceding with the jury, it would be the South Carolina Supreme Court. So that is what the defense is going to be pushing for. And if they don't get a change of law in South Carolina, they are going to push to go to the federal Supreme Court and ask the federal Supreme Court to say, essentially, look, South Carolina, get in line with the federal standard on this and change your law and hear this again. So there's a lot of post-litigation that is going to be happening. But the defense now says that there is evidence that wasn't turned over to them, evidence that they seem to think is exculpatory. We are going to take a quick look at Dick Harpootlian's statements to the media, because this is going to continue to make headlines, and I imagine some of those are going to look like Alex Murdaugh getting a new trial. There's a long way to go before that. But if South Carolina changes their law, Courthouse Becky's actions with the jury could force a new trial on the murder case. That could happen. It is within the realm of possibility. I can't sit here and tell you under the law that that would never happen, because the standard that you would have to meet federally is, did she speak to the jury? And she did speak to the jury. That's what was found during that hearing with Justice Toll. And for those of you that have not followed this case a lot and are like, wait, what is this? I will link everything down below if you want to see the fallout after the Murdaugh trial, because I've covered it extensively. Let's take a quick listen to what Dick Harpootlian had to say in his latest interview with Fox Digital. We're going to go through that kind of briefly. It's a shorter interview, but it's interesting to hear him talk about how they see their appeal and this new evidence that he is saying was not turned over to them. Now, he is talking about evidence that is text messages between his client, Alex Murdaugh, and Eddie Smith, who may be related to Murdaugh, who the defense says is Murdaugh's dealer, who has not been convicted of that. So if you are newer to the Murdaugh case, some of this may be a little confusing without watching the rest of it, but this ongoing question about this witness that was never called at trial, and I was surprised wasn't called at trial, Dick Harpootlian is starting to talk about, look, the evidence you have informs the decisions about who you call at trial and who you don't, and those decisions may change based on the evidence. And if the defense argues that this is exculpatory evidence that was not disclosed to them, that can be grounds for a new trial as well. And you can actually bring a motion for new trial that you didn't bring before on grounds of newly discovered evidence that was not disclosed by the prosecution, which is what Dick Harpootlian is alleging here. I am interested to see, of course, the state's reply to that, because these are messages seemingly between Alex Murdaugh and Eddie Smith. Did they not have Murdaugh's phone dump? Was this from a burner phone? I'm curious as to the circumstances surrounding this evidence.
One of the big decisions in any trial like this is who you call as witnesses.
Absolutely agree.
If you remember,
to any trial,
Eddie Smith, allegedly related to Alec, who is admitted, and the state asserts that he processed maybe millions of dollars of OxyContin to Alec.
That seems excessive.
Those texts, the ones we don't have, indicate a little more of the timeline of those distributions, and some of them are the week of the murder.
Which can be important.
We were not aware of those. Had we been aware of those, it may have made a difference in our decision not to call Eddie Smith to the stand. I point out that Eddie Smith, based on what the Attorney General has said, is probably the largest distributor of OxyContin in the history of the state.
What?
And he has not been prosecuted. He's wandering the streets, I heard maybe out of the state. And we're perplexed why Eddie Smith has been given this preferential treatment when, once Alec was convicted, there was no reason not to go ahead and prosecute him. Everybody else has pled guilty. Everybody else that was indicted has pled guilty, except Eddie Smith. Now,
I mean, wasn't the only other person indicted Alec?
Would have given us additional information, we believe, and I've talked to Jim Griffin. It might have made the difference in us calling him to the stand or not calling him to the stand. So, yes, they're important. We have an appeal based on errors made by the judge during the trial, and of course, the attempt by, or maybe she did, the efforts by the clerk of court, Becky Smith, to
Becky Hill,
the jury. And that's a huge issue.
Curtis Eddie Smith, Becky Hill.
Many of the people we've had look at the appeal believe we have a substantial chance of getting a new trial just based on the jury tampering. And that is the clerk of court issue. An issue, if we get a new trial, it'd be an issue that would be relevant in how we prepare for that trial. If we don't get a new trial, then there's something called habeas or post-conviction relief. And if you find that police or prosecutors have hidden evidence that would have made a difference, you can appeal on that basis. So, but the state's brief on the underlying appeal is due August 8th.
And that'll be interesting to see.
30 days reply, and then the Supreme Court will decide whether to have argument.
In this, I'm interested to see if they attempt to file an updated motion for new trial or amend their motion for new trial to bring in and argue the issue that evidence wasn't turned over. They may choose to do that. They may not. Dick Harpootlian doesn't indicate one way or the other. He also is very couching in his language about this may have changed our mind, this may not, because of course they're going to not want the things they say publicly to change what they might file in appeal. But he is alleging that the state did not turn over text messages that happened the week of the murder between Curtis Eddie Smith and Alex Murdaugh. Now, of course, the clerk of court is Becky Hill, not Becky Smith, but we know what he means.
But more important is a judge, a former Chief Justice, Supreme Court, had an evidentiary hearing,
which we watched together. It's wild.
Conduct in which she found, A, Becky Hill was not credible, and B, that Becky Hill did attempt to influence jurors to convict Alex Murdaugh. She told several of her coworkers
the evidence showed
she was writing a book, and if it would be better for book sales if Alex Murdaugh was convicted. So we think that and there is no clear state precedent on whether that's enough. But there's a clear federal precedent that we should get a new trial. So again, I think we should hear something before the end of the year or early next year.
Murdaugh's strongest argument on appeal at this moment, until I see more, remains that Becky Hill attempted to influence the jury. But remember, when Justice Toll held that hearing, the jurors said they were not influenced, the deliberating jurors. So what I find more concerning, though, is in the media reports, Dick Harpootlian is saying that one of the jurors that was dismissed was expressing her opinion on this case in the jury room to other jurors before they began deliberations. What's interesting to me is in this report, they are reporting that Harpootlian said one juror, dubbed the Egg Lady. Remember, this juror was removed before deliberations. He says was vocal in the jury room about her doubts and was dismissed just days before the verdict based on information provided by Hill. A, no juror should be vocal in the jury room about their doubts before deliberation. That's inappropriate. And B, she was removed because she was talking about the case to outside third parties about it. But yes, Hill is the one that presented that information. The removal of this juror is something the defense has continued to talk about, but it's not the ultimate issue here. The ultimate issue is whether or not Hill, the clerk, who was a state employee, tried to influence the jury that she had access to. And in this article, Harpootlian goes on to be quoted as saying, if we don't get a new trial, then there's something called habeas or post-conviction relief. And if you find that the police or prosecutors have hidden evidence that would have made a difference, you can appeal on that basis. So all in all, the defense may have multiple grounds to argue that Alex Murdaugh deserves a new murder trial. Ultimately, he is serving more than 50 years on all of the financial charges. However, if he chooses to go to trial again on the murder conviction, the amount of evidence on his financial crimes might be curtailed. He has pled guilty to a lot of those crimes, but the prosecution argued that those were part of his motive leading up to the murders of his wife and son. But you are going to be seeing more headlines about whether or not Alex Murdaugh is getting a new trial, especially with that deadline of the reply brief due in August. Once we have both briefs before the Supreme Court in South Carolina, we will talk about them again because I'm interested to go over those briefs. But if South Carolina adapts the federal standard, it is possible, I'm not saying it's going to happen, but it is possible that we could see another Murdaugh murder trial. And I have conflicting feelings on that because the actions of Courthouse Becky are so egregious that a defendant in Murdaugh's position should not be concerned that court officers who might have more of a position of trust with the jurors would take advantage of that and take advantage of that to influence the jury. That should not happen. It's abuse of the system, and it's abuse of your position of power. However, Emily, there's no however to that. It's an abuse of power of the system. I know. But Murdaugh used his position as an attorney with people that he trusted to steal from them when they were the most vulnerable. When you ask, Emily, is there a conflict? My emotions are conflicting. Logical lawyer Emily is not conflicted. Human emotional Emily is like, oh, weird. Someone taking advantage of a position of power to someone's detriment. Maybe it sounds a little like karma, but our justice system doesn't flow on karma, so we can't just go with vibes. However, Alex Murdaugh would stay in prison if he got a new trial. Alex Murdaugh is still in prison for an incredibly long period of time, even if something happened in the murder case. And that is why the state continued to prosecute and the feds continued to prosecute all of the financial crimes against Alex Murdaugh. Because if something happens to one conviction, there are still others that he is serving decades on. So, is Alex Murdaugh getting out of prison anytime soon? No. But the appeal over his trial is something I am keeping a close eye on, and this information about whether or not the state withheld evidence is just starting to break. So I'm going to be keeping a closer eye on that because I definitely want to hear more about how the defense found these texts, when they were turned over to the defense, why the defense didn't have them when they had the rest of Murdaugh's digital information, if they were withheld, even though the defense is alleging that they are. I still want to wait for some more facts coming in on Murdaugh, but for today, that's what we know. So, Law Nerds, it's time for me to go. Happy Monday, and I will see you in the next one. Don't forget to get the Law Nerd app at lawnerdapp.com because We have some streams this week where we need to talk about what's going on in Kohberger, and some streams coming up the rest of the month that you're not going to want to miss. Laundered app at launderedapp.com, free for you, iOS and Android. So I will see you in the app. I will see you in the live streams over on the live stream channel at the Emily D. Baker. And that sentencing hearing again for Kohberger is on Wednesday, the 23rd. If anything changes between now and then, I'll also let you know in the app. All right. Thank you for being here. Thank you for being a Laundered. Take care of yourselves. Take care of each other. And I will see you in the next one. Well, which will be on live stream tomorrow. So see you in the chat. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Laundered app at launderedapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Laundered.